Divorce is an incredibly complex and emotional process. Not only is your marital relationship ending, but you gotta decide who gets what and divide all of your property. This is one of the most important parts of the process. As a family law attorney, I've seen how this can be an area of great confusion and stress for divorcing couples. Hi, my name is Brooke Hallisey, and I'm an attorney with Schaefer Family Law Group. Today, I want to walk you through the first step in determining how property will be divided in a California divorce: the mandatory disclosure of all assets and debts. California is a community property state. This means property is either community property or separate property. Community property includes all assets and debts acquired during the marriage and is subject to equal division between the parties. Separate property is anything acquired before marriage, after separation, or by gift or inheritance. Separate property is not subject to division and belongs to the person who owns it. When you are getting divorced, we must determine what community property there is to divide, what there is in the marital pot. We identify community and separate property by requiring each spouse to disclose all assets and debts, or lay all their cards on the table, so to speak. While parties may try, there are no secrets as to property in a California divorce. If it exists and you know about it, it must be disclosed. Specifically, each spouse must serve the other party 3 legal documents called the Preliminary Declaration of Disclosure, an Income and Expense Declaration, and a Schedule of Assets and Debts, referred to collectively as Preliminary Disclosures, or PDODs. This is a mandatory step in a California divorce. You cannot go forward with the dissolution, even if you and your spouse agree to, without filing with the court a statement under penalty of perjury that you each completed and exchanged your preliminary disclosures. Failure to provide complete and accurate preliminary disclosures can result in court-ordered monetary sanctions. Preliminary disclosures are so important because the court wants to avoid the parties taking unfair advantage of each other, as spouses are in a fiduciary relationship with each other, which imposes a legal duty of the highest good faith and fair dealing on each spouse as to the other. This means, by law, each spouse is equally entitled to all information about community assets and debts. If a spouse is not satisfied with the information obtained in the PDODs, they can issue discovery requests for additional information from their spouse. Then, full and accurate disclosures must be made again before judgment is entered on the divorce, called your final disclosures, or FDODs, or otherwise waived as part of a settlement agreement. All of these financial disclosures are necessary so we know what property there is to divide in the divorce and nothing is left out or one spouse is unfairly disadvantaged. Given the complexity and legal requirements around financial disclosure, it's absolutely essential for each spouse to work closely with a family law attorney. They can ensure you are fully complying with all the disclosure requirements, assist you in obtaining additional information from your spouse about community assets and debts if they are not cooperating, and help protect your financial interests in the division of the marital estate. Trying to navigate this process alone, without proper legal guidance, puts you at risk of making costly mistakes. If you or someone you know is facing divorce, I encourage you to reach out to a family law professional who can guide you through this critical aspect of the proceedings. You deserve all of the community property you are entitled to under the law, and as a family law attorney, our job is to advocate for your best interests and ensure you come out of the divorce process in the best way you can.